Hello, and thank you for joining us today for our webinar. My name is Kristen McCalla, and I am going to go over a few housekeeping items for the program and how to use the software before I turn it over to our presenters. The audio will stream automatically upon entry through your computer speakers. If you're unable to stream your audio, then please click this phone icon that I have highlighted here, and a dial-in number will appear that you can call in. I encourage you to send us questions through the Q&A feature at the top of the screen, and then you can type your question down in the text field below. Download a copy of the PowerPoint slides by clicking the Files button and selecting Save as a PDF type. And offering CLE credit for the program. So if I will come on the line 4 times with course codes, and just remember those, and then email me at the email address I have here, McCalla, K, McCalla, @pepperlaw.com, and I will send you the CLE form for you to complete and send back to me, and we will get your credit processed. And I will turn it over to Jan.
Kristen, and good afternoon to those listening, and thank you for joining us this afternoon. My name is Jan Levine. I am the co-chair of the Commercial Litigation Group at Pepper. I focus my practice largely on antitrust, fair trade practices, and consumer protection law, mostly in the class action context. I handle a wide range of matters in the healthcare arena, including defending hospitals, hospital systems, pharmaceutical companies, and also in the food and agricultural industry and expansion of the healthcare industry. I am here today with my colleague, Megan Morley, who has a wealth of experience litigating antitrust cases and counseling clients on a broad spectrum of antitrust issues, including mergers and acquisitions, government investigations, and Scott-Rodino filings. By way of introduction, our topic for today is trade associations and their relationship to the antitrust laws. We're going to divide our discussion over the next hour into 4 parts. I'll spend some time giving you an overview of the issues and some basic concepts of how trade associations and antitrust overlap. Megan will then talk about government enforcement actions. I will follow up on the civil litigation side, and then we'll conclude with discussing benchmarking and standard setting. And if we have time, we will take questions, but if not, please email us. We will be happy to get back to you. Trade associations do many pro-competitive activities. The employment agencies and courts recognize that trade associations perform lawful and useful purposes. Some of them develop safety protocols in many industries. They lobby the government, establish environmental, technical, or product standards, certify products which give a level of consumer protection and understanding about products. Associations compile industry-wide statistics or benchmarks to help members efficiently run their businesses. Later on, we will talk about how to deal with statistics and data that can be shared among competitors with lowering antitrust risk. That's the benchmark portion. Associations also institute best practices, and they also jointly fund research. So those are all of the pro-competitive activities that trade associations do. So the question is, if all of those are legitimate pro-competitive activities, what matter? What are we talking about? What are the risks? And the risks are that competitors' employees in the same place at the same time can lead to allegations in both civil and criminal matters of collusion. The Federal Trade Commission can and certainly has investigated trade association activities, which Megan is going to talk about. Benchmarking activities can implicate the antitrust laws in that if you don't do it correctly and information is given which competitors can actually project future prices on, that can create some antitrust risk. Trade associations that function as standard-setting organizations, while standards are generally very good, also face additional antitrust concerns because whenever a standard is set, there also can be a lessening of competition. So now to go over some of the antitrust fix, as I call them. These cases, what we're going to focus on today really are Section 1 cases, Sherman Act Section 1. And Section 1 says every contract, combination, conspiracy, and restraint of trade or commerce is declared to be illegal. And that is really a two-step analysis. One is, was there an agreement? And there are reams and reams of cases and discussions and analysis on was there an agreement. An agreement is defined by the Supreme Court as a conscious commitment to a common scheme designed to achieve an unlawful objective. To be an agreement, you do not need a formal or written agreement. That is not required, although it can be. The issue really focuses, as the definition in Monsanto says, on a common purpose or understanding. And agreements really are established with two different kinds of evidence. One is direct evidence, and that is evidence where you actually, maybe you have a written agreement that actually fixes a price. You know, someone says, you know, a group of competitors get together and decide to fix a price, and they actually put in an agreement. That usually doesn't happen. But the concept of a smoking gun or a smoke-filled room where people are fixing prices and it's on tape and you hear it, that would be direct evidence of agreement. Most civil cases don't really have direct evidence. It's really circumstantial evidence. And the question is, different things happen, and the question is that an agreement? And you're putting the pieces together. In the civil context, that's really where there is a focus on trade associations, to try to engender or present the plaintiffs that try to present substantial evidence of an agreement that can get them to a jury. And sometimes trade associations and trade association activity is used to develop the circumstantial evidence for an inference of agreement. Two, after you develop, or the plaintiffs try to develop an agreement, there is no agreement, there is no violation of the Sherman Act 1, and we stop the analysis right there. But assume there is enough evidence of agreement. The next question is, does the agreement unreasonably restrain competition? Now, in statute, there isn't the word unreasonably, but the law is you have to have an unreasonable restraint of competition because every agreement, even if it's a defined agreement, in some way restricts competition. You have an exclusive dealing that is perfectly okay under the antitrust laws, it still restrains competition, but it's okay because it doesn't unreasonably restrain competition. So on step 2, there are really two approaches. There is a per se standard, and per se agreements are so pernicious to the concept of competition that they automatically restrain competition and are illegal. So courts have found, assuming there's no antitrust immunity, that activities such as outright price fixing, outright bid rigging, outright agreements to restrict output or sales volume, outright agreements to allocate products, geography, or customers, outright agreements to fix wages, or outright agreements to not poach each other's employment or group boycotts, or fall into this per se, which means you don't have to discuss whether it's an unreasonable restraint or not. These types of activities are deemed to be unreasonable. In many cases, however, really are decided, I think most cases are decided under the rule of reason. So if it is not per se, then the agreements are examined to determine whether or not the anti-competitive effects of the agreement outweigh the pro-competitive benefits. And it becomes an evidentiary issue. So if you're in the rule of reason, you can bring in the evidence of the pro-competitive benefits. And recovery, with limited exceptions, civil complainants can seek treble damages and reasonable attorney's fees for violations of the antitrust laws. Now have the basics down. We'll turn to government enforcement.
I'm going to give the first keyword, if you don't mind.
Sure.
So the first course code is government.
Thank you, Jan. So I'm going to discuss some issues around government enforcement of the antitrust laws. And the first thing I would like to discuss is sort of why is this important from a government enforcement perspective. And what you need to understand is that the criminal penalties for violations of the antitrust laws can be pretty severe. With respect to individuals, they can face up to a $1 million fine or twice the resulting gain or loss effect of the agreement, and if that is above $1 million. Individuals can face prison time from up to 10 years. And actually, the average jail sentence for those who have pled to violating the antitrust laws from 2010 to 2016 was 22 months. And that is 3 times the average sentence that occurred in the early 1990s. What we're seeing through the years is that the DOJ is seeking bigger sentences. From the corporate standpoint, the penalties are severe as well. As the statute reads that it's criminal fines up to $100 million, or again, it's this twice the resulting gain or loss from the antitrust conspiracy. The largest fine to date was actually $925 million, and that was associated, that was from Citigroup with respect to pricing in the foreign exchange rate. There's been some other very significant fines with that conspiracy. The DOJ can also place restrictions on future business as these penalties. And so I was going to go over an example of a criminal enforcement action that dealt with trade associations. And this is a little bit older of an example, but it's interesting because it was actually made into a movie. That does not occur with antitrust cases very often. So what occurred here is this was an investigation of lysine producers. And this occurred in the late 1990s. And the conspirators in this conspiracy created a subcommittee of the European Feed Additives Association, which was a legitimate trade association group. But they created this subcommittee as a way to meet and collude regarding lysine prices and production. And what occurred via, as this movie is called, an informant, the FBI was able to tape meetings between these producers. And the co-conspirators were actually caught on tape discussing how they would use this sort of fake subcommittee as a cover for price-fixing meetings. It went so far as they actually created false agenda and false minutes for these meetings that they would submit to sort of the lead, the European Feed Additives Association, which again was a legitimate trade group, and they would list all sorts of topics that weren't actually discussed, and the topic miscellaneous was sort of a code word for discussing fixing prices and allocation of markets. And this case occurred, or this matter occurred quite a few years ago, but the biggest fine was levied upon Archer Daniels, and it was for $100 million. And one practice pointer I wanted to point out is that although we are discussing trade associations in this webinar, that these type of things apply to other situations in which competitor employees might be in the same place at the same time. That could be trade shows, other industry events. A customer is having some sort of dinner, or a customer is throwing some sort of golf outing. Anytime competitor employees are in the same place at the same time, there are antitrust risks. And so, for instance, in the auto parts manufacturer case or investigation that's occurring right now with the Department of Justice, in which they have, I think, received over $2.5 billion in fines from auto part manufacturers, there are allegations that these manufacturer executives were able to, or that they at least attended the same auto shows and these auto parts expos, and therefore were in the same place at the same time. Another area to discuss with respect to government enforcement is not in this criminal arena, but the Federal Trade Commission able to use what is called Section 5 of the Federal Trade Commission Act to also impose what could be penalties. It's more usually sort of an injunctive or penalty, but they're able to use this act in order to prohibit certain trade association activities. And it's important to note that Section 5 of the FTC Act, it prohibits other methods of competition. The actual bounds of Section 5 are not exactly defined, and it actually goes sort of beyond the Sherman Act. And it really involves sort of violations of the spirit of the antitrust laws. And therefore, at least in the past few years, it's been used pretty broadly. And they've used it in some of in the recent past against trade associations to issue consent decrees or reach agreements with these trade associations to prohibit certain behaviors. I'm going to go through a few examples. In 2009, there was a consent decree issued with the National Association of Music Merchants. And what was happening there is that it was alleged that at these trade association meetings and through the trade association, the members were exchanging information about retail price floors, or RPM, or retail price maintenance, in which they're sort of setting the floor for what you set your retail prices for. And so this organization and the FTC reached an agreement in which the FTC prohibited NAMM from encouraging or facilitating the exchange of this retail price information, pricing policy information, margin information, and terms of sale information between its members. And in the next two matters I'm going to discuss are actually very similar, and the consent decrees were issued right around the same day in 2014. And the first one was with the California Association of Legal Support Professionals. And in this situation, the consent decree prohibited CalPro from banning comparative ads and preventing members from offering discounted rates to another member's clients or recruiting another member's clients. So basically what was occurring was that there were rules in place that you weren't supposed to seek another member's clients or try to solicit them for business, and the FTC stepped in and put in this consent decree that prohibited that behavior. Similarly, in the Music Teachers National Association matter, which was also in 2014, the decree prohibited MTA from restricting, or as it was in this case, declaring unethical music teachers soliciting clients from a competitor teacher. In this case, the code of ethics of the trade association actually prohibited one music teacher from soliciting clients from another teacher. The FTC stepped in and prohibited that behavior. In addition, just to mention, with respect to all of these consent decrees, another aspect of it, which was just a little too much information on the slide, was that there usually was a part of it that instituted that these organizations had to put an antitrust compliance officer to make sure that, they would comply with the consent decrees and these settlement agreements, but also to try to avoid any future issues. One other item I wanted to note before turning the program back over to Jan was that it sort of remains to be seen whether the FTC under the Trump administration will be as active as the Obama administration was with the use of Section 5. And it's important to note that President Trump has appointed as his acting commissioner Dean Olhausen, who is considered to be somewhat more conservative, at least from antitrust perspective, than some of the prior commissioners. And so she actually recently, as of yesterday, has given some comments to different groups. I think yesterday was the Federalist Society, that she sort of wants to rein in the FTC's use of Section 5, or just their use of, what they're going to do, and not just go after what she said were cases in which she thought there would be an unfavorable market outcome, but also go after instead cases or situations in which there is actually evidence of an anti-competitive effect. So it sort of remains to be seen, but at this time, he has put in place not only Olsen, but also Joshua Wright, a former FTC commissioner, is also working with Trump right now, and he is also known for being conservative as well. So the FTC might be less aggressive, but we'll see.
Thank you again. And now we're going to talk about some of the private civil antitrust cases. Trade associations and their members can be a focus in civil litigation. Many Section 1 complaints, in addition to a lot of other allegations, also contain allegations regarding trade association membership and contemporaneous presence of defendants at trade association meetings, largely because you can claim competitors were in the same place at the same time. That is really why trade associations often find themselves creeping into these large antitrust class actions, really to what I was talking about before, to try to convince a court of an inference or circumstantial evidence of agreements to fix prices or other antitrust aspects, because people who are competing are in the same place at the same time and obviously having discussions about their industry. Now, the civil standard is very clear that opportunity to conspire without more is sufficient to sustain an inference of conspiracy. And if all that is alleged is an opportunity to conspire, that makes a very strong motion to dismiss, because the law is really quite clear. Just because somebody could conspire doesn't mean that they did. However, the law is also, and this has nothing to do with trade associations, but you look at conspiracy allegations usually in their entirety. So when courts scrutinize antitrust allegations, they're looking at the whole picture ordinarily. So in the drywall case, the court laid it down this law clearly. Opportunities to conspire may be probative of a conspiracy when meetings of defendants are closely followed in time by suspicious actions. So you see, it's not just the opportunity to conspire, but a price rise or another quote-unquote suspicious activity happened in time to when the alleged defendants or the defendants were at a trade association meeting. So the real question becomes, when you look at these cases, is what is enough circumstantial evidence that a court would allow a case to go to a jury rather than to grant summary judgment? That is really where the focus of trade association activity is in these class actions. And, courts, obviously do weigh that and look at evidence. Is that evidence, more likely to reflect unilateral behavior? It is fine to be at a trade association, and it's fine to talk about a lot of things in the industry, or were these pieces of an evidence really enough to establish an agreement and restraint of trade? What the courts really look at and what the allegations are. So for the next few minutes, I'm going to talk about 3 cases where trade association allegations were made. Now, these 3 cases, I want you to know, are not largely about trade associations. So if you read them, the trade association arguments are within these very lengthy cases, and I'm going to give you a high-level overview. But if you do look at these cases, they're complicated antitrust cases, and they largely involve oligopolistic behavior. That is, a small number of competitors in a market. And when there's a small number of competitors in the market, there can be parallel pricing. One competitor raises the price and others follow. It is called, in antitrust jargon, parallel pricing or conscious parallelism. And in these types of markets, where there is interdependence because there are a few number of competitors, there can be parallel pricing. Parallel pricing is not enough to make out an antitrust violation when there's an oligopolist market. In these cases, you're starting to look at reasons, the courts look at it as you can't just show parallel pricing, you need to show parallel pricing plus factors to see if there's enough to have an inference of an agreement. That is where trade associations, again, come into play in these cases. So the first case where summary judgment was granted here in the Middle District of Pennsylvania, affirmed by the Third Circuit in 2015, is the famous In Re chocolate case, as we talk about it. There were 3 defendants in that case: Hershey, Nelly's US, and Mars. And I'd like to say that Megan was on the Mars team, did a terrific job. The aim was that these companies conspired to raise the price of certain types of chocolates multiple times between the time period of 2002 to 2007. Plaintiffs include allegations that the defendant executives attended the same Grocery Manufacturers Association meeting. And this is what the court had to say about those allegations. The court was very tough and really said that the evidence presented by plaintiffs shows only that top executives from the defendant manufacturers were among hundreds of other attendees at the Grocery Manufacturers Association trade meeting in June of 2004. Plaintiffs have not discovered anything more insidious. The court rejects the suggestion that contemporaneous presence of defendants' officers at a trade association meeting permits an inference of conspiracy. This suggestion is pure conjecture, and it is insufficient to carry plaintiff's summary judgment burden. So in short, what the court was saying, same place, same time, is just not enough. Now, this decision was reached on a full record. The initial complaint was filed in 2007 and 2008, so the plaintiffs withstood motions to dismiss. But after all the evidence was in, the court found no agreement, and that was the end of the case. The next case that I wanted to talk about is the text messaging antitrust litigation. Again, basically a market of a small number of players, AT&T, Verizon, Sprint, T-Mobile, and this time the association itself was named as a defendant, the Wireless Association, which the defendant companies all belong to. The conspiracy claim was that these defendants tried to increase the price of one type of pricing for text messaging and this was called price per unit, PPU, rather than bundled pricing. We were talking about just PPU pricing. And case, summary judgment was ultimately upheld by the Seventh Circuit in 2015. But historically, the Seventh Circuit had affirmed the denial of a motion to dismiss in 2010. The Seventh Circuit, when it got to the allegations about associations, it wrote that the allegation in the complaint that defendants belonged to a trade association and exchanged price information directly at meetings was of note. And I went back, and I can actually read you the allegations in the complaint. They really had two complaints about trade associations. One, an allegation that the defendants belonged to the trade association and exchanged price information directly. And so when you look at a motion to dismiss, you can't debate it. You have to take it as given and given as true. So there was an allegation that there was direct price information exchanged at the association meetings. And two, the complaint alleged that the defendants, along with two other sellers of text messaging services, constituted and met with each other in elite, quote-unquote, leadership council in the association, and the leadership council's mission was to urge its members to substitute, quote, cooperation for competition. So with those allegations, and I'm sure a lot more, motions to dismiss were denied, but after a full record and after discovery, the Seventh Circuit determined that the case should be thrown out entirely. Regarding the trade associations, the court noted that three aspects. The presence of non-conspirators at these meetings made the probability of collusion at the events less likely. There was a substantial lag between the meetings and price increases, so this idea that you could infer that an agreement or a conspiracy took place was really unavailing. And, at the end of the day, there was no evidence presented by the plaintiffs of what information was even exchanged between the defendants and the meeting. So this is an example of, regardless of what's in a complaint, after a full record and you drill down, evidence of an agreement was really simply just not there. The case that I am going to discuss is a very heady case. Again, small number of competitors in this market. This is the titanium dioxide antitrust litigation. At this time, summary judgment was denied. The case was a price-fixing case in the market for titanium dioxide, an ingredient in paint, and the plaintiffs were largely paint manufacturers. And it got to the issue, when the court got to the issue in a very long opinion about the trade association, the court really found four aspects troublesome enough to deny summary judgment, so a jury could consider the circumstantial evidence and decide whether or not to infer a conspiracy or agreement or not. These were the four aspects that the court identified. First, the frequency of defendants' price increases dramatically changed after the trade association, Titanium Dioxide Manufacturers Association, which had been previously exclusive to European manufacturers, opened its doors and allowed others in DuPont and a Japanese manufacturer. And apparently, after that happened, there were significant price increases. Second, the trade association had something called a global statistics program. And the program involved monthly recording of previous month's production and inventory data. And that is something that Megan is going to talk to you about, benchmarking. That was of great concern to the court. That was not historic enough, and the court really felt you could use that data to actually fix future prices. Third, as I said before, the price increases announced were in very close proximity to the trade association meetings. In fact, 88% of the increases announced were within 30 days of the meetings. That gave the court great concern. And as always, there are the emails, and two of them in particular were used to defeat summary judgment. The first was an internal send-in communication called the Statistic Program that I just talked about, an important effort for us to get the industry to make more informed decisions and, quote, the best opportunity we have in structuring industry data for all our collective needs. It's really a good idea not to use the word collective when you're dealing with kind of information. Another email said, the timing may be no coincidence because their reading of the global statistics information like ours should give them confidence that the trade association price increases, that the defendant price increases can be prosecuted despite the flat market in North America itself. So that is an example, unlike the other cases, when there was enough circumstantial evidence around trade association meetings and between the competitors to defeat summary judgment and to allow a jury to decide whether or not you can infer agreement from this evidence and obviously other evidence and economic evidence in the case. And that, we are going to move on to benchmarking.
I'm going to go ahead and give the next two code words, if you don't mind, Megan. Sure. So the first word that I gave earlier was government, and the second code word will be agreement, and the third word is antitrust. So again, it's government, agreement, antitrust.
Thank you. And as Jan was just discussing, this global statistics program in the titanium dioxide case did play a role in the court's opinion denying summary judgment. However, benchmarking can be totally fine, and in fact, generally in the U.S., the exchange of non-price and historical price data is acceptable if certain guidelines are followed. One important guidelines is that an independent third party should be the one that operates the data collection, that analyzes the data, aggregates it, and compiles it, and then distributes whatever sort of report is made from the data that's received. This helps keep a sense of independence between the different competitors at the trade association, that they're not seeing each other's data, that an independent third party is receiving the raw data from each competitor and then doing the compilation. And not only that, but the third party should ensure that there's appropriate firewalls so that the participants, the different competitor members of the trade association, access each other's data. As Jan was alluding to in the titanium dioxide case, another important guideline to follow is that the older the information provided by the participants, the better. In fact, it's preferable that the data should be 3 months old or older. As Jan pointed out in the titanium dioxide decision, the data was only a month old, and as you could see from the defendant emails, it seemed even the defendants believed that they could use that data to interpret, that it could be a good time for a price increase. Very importantly, that any sort of report that is created doing this sort of benchmarking, data compilation, it only be distributed with aggregated data. Therefore, if there are multiple members of a trade association that are competitors, and for instance, they give data to a third party about their shipments for a quarter, a month, the third party should then turn around and distribute a report saying company X shipped X tons of, widgets in this month. Instead, what should happen is that data should be aggregated and say, all participants shipped, this aggregated number of tons over this month, over this quarter. And sometimes data can be broken down by region and other sort of geographic units, by product possibly. But what you should realize is that there should be at least 5 participants report data for each statistic. So for instance, if you're reporting tons for a certain state or certain region of the U.S., you should make sure that there's 5 or participants that compete and are providing data. The reason being, if there's only 2, it's pretty easy, even if that number is aggregated, for you receive that number, the 2 players in that region receive that number, and they know what they had, and they can easily subtract to figure out what their competitor is doing. So they want more participants because it allows, it's likely a chance that you'll understand what each competitor individually is doing. And also importantly is that in each statistic, members should represent more than 25% of any particular, have a 25% share of any particular statistic. So again, for instance, if you're looking at a statistic for a certain region, if there's one player that really dominates that market, it's easy to understand what each individual player is doing individually, as opposed to just sort of looking at the industry as a whole. So those are some good guidelines to follow. And it's important to note that FTC and DOJ in 1996 came out with some safety zones as part of actually a report they did on healthcare. However, with limited exception, following these safety zones in establishing or being part of a benchmarking program or statistics program in a trade group does help to prevent any challenges from these agencies. Again, there's extraordinary circumstances. And also it can help in defending against allegations from civil complaints. For example, in the titanium dioxide case, obviously the plaintiffs were allowed to say, hey, this data was only a month old and it could be used. They could use that to fix prices. Whereas again, if you can rely on these safety zones and say, no, the data was really old, we used it internally just to understand business decision. It was not used as any sort of collusion or collective, I think was the word used in titanium dioxide, group effort in order to fix prices. And, from benchmarking, I'm going to move to another aspect that can occur with trade associations. Not all trade associations engage in standard setting, but do. And so we wanted to talk briefly about this today. And it's just important, just as sort of a background on standard setting, there are competitive benefits to standard setting. To give an example, and why I put and a nut and bolt little cartoon in the presentation, was that standards are important and they do provide a lot of pro-competitive benefits. For example, it's good that there are standard sizes for nuts and bolts and things like that. It makes things run efficiently. It makes it so contractors can go to a store and buy, different manufacturer nuts and bolts on different days and then not run into a problem when they're trying to build something. So they do provide lots of efficiencies, and the agencies and the antitrust laws recognize this. However, at the same time, when you are setting standards, there is the chance that it can lead to anti-competitive harms. For example, setting a standard could cause a barrier to entry, leading to someone not being able, a company not being able to enter and sort of play in a certain space. It can facilitate collusion, possibly. It can exclude competitors. You make a standard that you and a few other competitors get together and make a standard that sort of one other competitor in the field cannot meet, then they're excluded. So there are antitrust risks associated with standard setting. And so because of that, standard setting organizations need to ensure that there are processes in place for creating standards that are not anti-competitive. And I'm going to go over those shortly. But I also wanted to note that in 2004, there is an act went into force. So it's called the Standards Development Organization Advancement Act of 2004. And this provides some limited protections to standard setting organizations, or what the Act calls standards development organizations, while engaged in standard setting activities. And what this does is, if the standards development organization and employees of the development organizations are engaged in these standard development activities, that any sort of antitrust allegation will be examined under what Jan discussed as a rule of reason analysis as opposed to a per se analysis. In addition, any sort of damages sought will not be treble damages, but actual damages. Again, as I was saying, this is actually limited to the standards development organization itself, its full-time employees, not to members, say, of the trade association or the standard setting organization that belong to companies and are coming in to actually help create the standards. And also important to note that although this does provide some limited protections, it doesn't allow you to then say fix prices and get away with it. The protected activities under the Act exclude exchanging competitively sensitive information that's not reasonably required to create a standard, and it also excludes entering into any agreements to fix prices or allocate customers. So it doesn't protect you from everything. So as I was saying, because the antitrust law, because standard setting organizations and the standard setting process can implicate the antitrust laws, it's some questions, I pose them as questions to consider when sort of organizing how this process is going to work. And so first, one of the first things to consider, and these are in no particular order, I should say, is does the standard that you're working to create promote the goal it is seeking to advance, such as it could be a standard for making sure that there's a safe working environment for people in a certain industry. Uniformity, as I talked about, that nuts and bolts, kind of creating a uniform standard that really helps the industry as a whole work more efficiently. Or quality. It's important to make quality products, and so having some quality standards in place, again, that is a pro-competitive goal. Timely notice for the standard setting given to all parties believed to have a direct and material stake in the standard. And so kind of overall big picture for standard setting organizations to help kind of prevent any sort of allegations that the standard setting process violated the antitrust laws. It really should be about openness and fairness in the standard setting process. And therefore, notice should be given to those people or those companies that have a stake in this standard, and that can be different parts of the distribution chain. For instance, again, going back to some sort of construction standard, that can be the contractors, that can be the equipment manufacturers, that can be the distributors in between. So there's lots of individuals in a distribution chain who might have a stake in a standard, and notice should be given to all to be able to involved in the process if they choose. Again, does the standard setting process permit these parties who have this stake the right to participate and express their opinion about what standard is going to be put in place? And again, as I talked about before, if possible, are members of the standard setting process from various parts of the industry, not just manufacturers, but also the people who are using the product. That can be important to ensure that this is an efficient, to meet that goal of uniformity or efficiency or quality. Does the standard setting organization keep a written record of the standard setting process? And this can be very important because, again, as I think the next question I asked is there a way to review the process or an appeal process? Is there basically due process for members to come in and appeal and feel like they're fairly heard? Keeping a written record is important. If there's ever challenges, if there's complaints about it, you can say, we did X, Y, Z, and this is the way we always do our standards, and it was open, fair, and we heard opinions, and we reached that this standard was the best to meet our goals. And also, importantly, as I just mentioned, it's important to consistently follow its written standard setting procedures. In the case that it's ever challenged, it's important to show that you're consistent and it was a fair and open process. Part of standard setting organizations I'm going to touch on is something that's actually fairly relevant today. There's been some previews happening since 2017 in this space. And standard setting organizations, another thing that they implicate in terms of the antitrust world is what are called standard essential patents. Sometimes they're known as patent holdups. You might have heard that term used as well. And basically, what a standard essential patent, or SEP, SEP you might want to call it, is that a member of a standard-setting organization might hold a patent to certain technologies that are necessary to implement the standard. And without limitations, you assume that this patent holder could then get very, what we would call super competitive or very high royalties from its competitors if standard that needs that technology is adopted, or could feasibly exclude its competitors from even being able to license it, which basically would give it a monopoly. And so the standard essential patent holders can face antitrust scrutiny, both from the government and private plaintiffs, if it does not license this required technology upon reasonable and non-discriminatory, which is known as RAND, or fair, reasonable, and non-discriminatory, FRAND terms. And what's important to note is that for standard-setting organizations that typically require their members to disclose these IP interests involved in any developing standards. Again, this goes with the fair and openness, making sure that the standard-setting process is fair and open. And then also say to your members, okay, well, you have to license any standard essential patents that we adopt for these standards on RAND and FRAND basis to competitors. And for the standard-setting organization members that are holders of these standard-setting standard essential patents, you should be aware of any disclosure obligations you have regarding these standard essential patents that you must make to the standard-setting organization as part of this process. You also should consult with counsel regarding these obligations and any sort of RAND-FRAND licensing. And we don't have much time left, but I'm going to quickly talk about sort of two cases, one that is a little older but is sort of kind of known as a very big case in the standard essential patent world, and then one that was just filed in January. And so the first case I'm going to discuss is this Rambus case. And the FTC brought this case against Rambus, who makes what was DRAM, a type of memory. I'm not technologically savvy, but what the allegation was from the FTC that Rambus failed to disclose its DRAM patent interest to the Joint Electron Device Engineering Council, JEDEC, which standardized DRAM. And after this complaint was brought in February 2004, the administrative law judge dismissed the complaint, basically saying, one, this did not withhold material information to JEDEC, and two, there was insufficient evidence brought by the FTC to prove that JEDEC would have standardized an alternative if Rambus had made this full disclosure. The commission disagreed, and in 2006, it vacated the administrative law judge decision, determining that Rambus had engaged in unlawful monopolization. 2 points that it made was that Rambus intentionally misrepresented IP information to JEDEC, and that but for this misrepresentation, JEDEC would have excluded Rambus's technologies from standard, or, and that was sort of important in the next part of this, demanded RAND assurances. Well, the D Circuit disagreed with the commission, and it reversed, and it said that the FTC failed to demonstrate that Rambus's conduct was exclusionary. The court explained that the government needs to prove an anti-competitive effect, which in the antitrust world is a harm to competitive process or harm to competition, not just one or more competitors. You have to harm competition. And as part of this analysis, it said that the government provided insufficient evidence that JEDEC would have standardized an alternative technology had it known the scope of Rambus's IP. In addition, the court was not convinced that Rambus, using deception to avoid RAND licensing terms, harmed competition. Instead, an otherwise lawful monopolist's use of deception simply to obtain higher prices normally has no particular tendency to exclude rivals and thus to diminish competition. In fact, it went on to say that a lot of times monopolies lead to higher prices, but at the same time, it can lead to higher prices and also can less innovation. But this was a lawful monopolist who had this technology patented. also made the point that in the but-for world, if ADEC had still standardized the same technology, then Rambus's deception cannot be said to have an effect on competition in violation of the antitrust laws. Again, they were saying it might have harmed one or more competitors, but that doesn't mean it harmed competition overall. And that is what is required to show to violate the antitrust laws. And finally, with my last few moments, I'm going to talk about a very recent case. In fact, it was filed, the complaint was filed just less than a month ago on January 17, 2017 by the FTC. And the FTC filed this against Qualcomm, again, in this standard, claiming this sort of standard essential patent and monopolization. And what the complaint alleges is that Qualcomm applied a no-license, no-chips policy and refused to sell its baseband processor, which are some sort of computer chip, to any cell phone or tablet manufacturers that did not agree to the licensing terms that Qualcomm implemented. And what the complaint went on to say is, unlike Qualcomm, most component suppliers did not require these phone producers to pay for a patent license in addition to the price of the processor it was buying. And what it was saying was that these customers paid elevated royalties if they used chips from a rival of Qualcomm. That was actually part of the terms as well. And part of this complaint was that device manufacturers could not lose Qualcomm's chips because the devices would no longer work on certain networks, such as a premium LTE. In addition, they alleged that Qualcomm refused to license its standard essential patents to competitors, despite promises to do so during this standard setting process. So not only did it not license something on RAND or FRAND terms, it just didn't do it at all. That's what the complaint alleges. In addition, finally, I wanted to point out that the FTC noted that Qualcomm won an exclusive deal with Apple in return for billions of dollars in reduced payment royalties to keep Apple from buying competitors' chips. The FTC voted 2-1 to bring the suit. But importantly, a dissent was issued by the acting chairwoman, Maureen Olhausen, who I spoke about before, who has made comments about, reining in the FTC. And in fact, yesterday, as part of this Federalist Society meeting she spoke at, she also mentioned antitrust and IP and expressed concerns, again, about this case and this decision to bring this case. And also said that she feels that there needs to be the right balance between IP rights and antitrust. The FTC needs to strike a balance there, and she expressed concerns, as I said, about this case again during that meeting just yesterday. I also wanted to mention that private suits followed the FTC complaint, including Apple brought a suit with back to this the deal, and that Qualcomm, the FTC went after Qualcomm, but this is actually after the FTC went after Qualcomm, but this was after China and Korea had also gone after Qualcomm for its IP licensing practices and received both and Korea each fined Qualcomm nearly $1 billion for its IP licensing practices. So it needs to be seen what will happen with this case, but for now it's moving forward.
I have one question. I don't know if you want to address it.
What is it?
Sorry, in the question. The question is, has a manufacturer's suggested retail price ever raised the inference of an agreement? It would appear in an MSRP is an attempt to keep retail prices at a certain level rather than up to each vendor. Could be a hub and spoke conspiracy. So retail price maintenance, and Jan, if you want to address, please step in. Retail price maintenance can be an antitrust issue. Typically, it is looked at under the rule of reason, which is a case, I believe, around 2007, this case out of the Supreme Court called Legion Leather. And so, yes, it can raise the inference of an agreement, but again, courts in that case, especially when it's a suggested retail price as opposed to in a mandatory retail price and you reach an agreement with the seller that you're going to impose this price, is that courts, that more rule of reason weighing situation as opposed to the per se analysis that Jen mentioned, which would be in place for just a straight price fixing, bid rigging type of situation. Jen, do you have anything to add?
No, and we're talking about the federal antitrust law.
Yes.
Response.
Yes, that is under federal antitrust law. The state actually, depending on each state, has a different approach to retail price maintenance and whether it is examined under a rule of reason or per se analysis. And have to check state by state, unfortunately.
Great. I'll go ahead and give the fourth word. We are out of time. The fourth word today is patent. So your 4 words are government, agreement, antitrust, and patent. So I have the screen here again with my email address. Please email me if you'd like to receive the CA form, and I can send that to you and submit these 4 course codes to me, and we'll process your credit. So with that, I thank you all for joining us.
And you can send any other questions along.
All right. Thank you much for joining us. Have a great day.